Hi, everyone. Today's June 9th. I'm going to do a quick review of Chapter 3. I recently spoke to a colleague that specializes in online learning and videos, and she told me that anything more than 10 minutes is brutal, and most students don't like to tune in. So, later chapters, I might trunk out the information in sections so no one has to bear too long a video. And I have to admit, when I look for YouTube videos on how to do things or learn topics, I cringe when I see anything over 10 minutes, and I tend to avoid them. So I'm going to try to keep it simple and really go for the big nugget information that you can get from the book. Why be redundant if it's clear and straightforward and relatively simplistic? It's those nuanced details that I think you'd like to see a video about. But chapter 3 is about tort law. Tort law is private wrongs, those kinds of things that if the defendant, the wrongdoer, has caused physical injury or injury to someone's property or economic standing, there might be a cause of action or a right to sue. The one it starts with are intentional torts. Those are things like assault, batteries, unlawful confinement. Assault and battery can be a combination of the two. They often accompany one another. Assault being putting someone in apprehension of being offensively touched. The battery is the offensive touching without justification. And unlawful confinement is basically similar in the criminal realm of kidnapping, keeping somebody confined without consent with regard to liberty, without justification. Those don't come up too much in business. They do once in a while. Businesses will be liable for those kinds of actions, or their agents or employees if they engage in them. The problem is the insurance doesn't cover them, because if insurance could cover intentional torts, it would take away the incentive for people to behave as a society. And most of them are dealt with through the criminal process, because restitution usually takes a part of the justice system in the criminal realm, an element of that to resolve a case. So it's not that big intentional torts, but you should know the elements. It requires the defendant had to intentionally cause the consequences of their act, and that's proved by the surrounding circumstances of their behavior. And then there has to be damages that are caused by that. It's called proximate cause. Sometimes it's but for you punching me in the face, I wouldn't have chipped my front tooth and needed that dental work. Usually it's common sense, but we're going to get to proximate cause more in the negligence section in a second. It's not always as easy as it sounds. Negligence is the big one I want you to worry about in business law. It's a common law principle, meaning it's court created. It's been in our history of our nation pretty much since its inception. It's been over in Great Britain even prior to that. And it has four major elements. One is we all have duties. Whatever we're doing, driving a car, ironing a shirt, walking down the street, we have a duty of care to behave in a certain way that's reasonable and appropriate under the circumstance. It's all contextual. Different contexts require different types of behavior. And it all relates to foreseeability. You should know that behaving like that puts people or property at risk. If you breach that duty and you injure someone's property or their person, you would be held liable. And that's the nutshell. It's a very common sense principle. It's an equitable principle. We kind of know it when we see it. But we all owe duties at every given moment of our lives. It just depended upon the foreseeable circumstance that you find yourself in. The way I drive my car in the city with many pedestrians on both sides of the sidewalk and cars pulling out from the curb, and a lot of intersecting traffic is very different than I'm driving on a rural road with a great deal of visibility and meadows on both sides and no other traffic. One's a heightened degree of foreseeability for potential hazards as opposed to the other. And so you know it when you see it, and it exists everywhere in life. That duty we all carry with us, and when we breach it, all that means is we failed to act as a reasonable, prudent person would in that circumstance. It's easy to define, but it's actually difficult to apply because many of us have different values and beliefs on what is reasonable. Some are very cautious people, and they think you should act in a certain way. Others are more carefree and freewheeling in their behavior. It's an amalgamation of all of our views as a society, what's reasonable. It's not perfect behavior. It's not the behavior that in hindsight you could have done better. It's what a reasonable person would have done at that moment. We have debates about it and trials over that very question. But if you fail to use reasonable care and you cause somebody injury, I was texting, I rear-ended the car in front of me at the stop sign, I pulled up too quick because I was texting, I damaged the rear end of the car, it cost $1,500 to fix. That's clearly damages I caused. It's the proximate cause of their loss. What proximate cause means is it could be just the but-for cause. But for my negligence, that event wouldn't have happened. But proximate cause is a more difficult concept to really understand. It also has to be a foreseeable consequence. What do I mean by that? Sometimes we engage in behavior and a sequence of events will happen as a result of that we're not really reasonably calculable in hindsight. I always think of Homer Simpson from The Simpsons show. I don't know, some of you might not be familiar with it, but Homer's basically a kind of a goofball, and he gets in a lot of different strange situations, most of them ending in nuclear meltdown, literally in the show, or something very catastrophic, even though his initial negligence was relatively minor and the foreseeable consequences didn't seem like they would lead to these bizarre ultimate conclusions. If the foreseeable consequences are different than what the injury actually is, we usually don't hold people accountable for very remote events. So I always think of the example of, if I did a fender bender with you and as a result of that, you broke your pinky and you need to go to the doctor. But as a result of going to the doctor needs to suture you up and put some stitches in, but they unfortunately didn't have the cleanest protocols in the hospital, and you got hepatitis from one of their instruments or something like that. You wouldn't have gotten that if it wasn't for me rear-ending your car. But is there a foreseeable consequence for rear-ending your car through texting that you might get hepatitis? It's a bit of a stretch. So we don't hold people accountable for very remote outcomes, even though they put those dominoes in effect, if you will. And it's a tough call. I can't always answer that, and a jury often has to determine, is this the proximate cause? The other concept related to it is the nexus. And this doesn't come up too much in business law, but it does come up in tort law generally. So, for example, my father, when he was getting much older, he had to take arthritis medicine for his hands. And it turned out that the arthritis medicine was recalled and banned by the FDA, the Food and Drug Administration, because it was causing heart problems. And my father said, I want you to go and sue because he had heart problems. And I said, well, Dad, you're 88 years old. You smoked a big part of your life. You drank most of your life, and you still did right up until the day you died. And you ate terrible dietary intake your entire existence. And your father had heart disease, congenitally. How can we prove that the anti-inflammatory medication that you're on, the arthritis medication, actually caused the nature of the heart disease you have? How do we make that connection, the proximate cause? And that can be difficult sometimes. In business areas, it's not going to come up too much, but it's just an interesting concept because it does come up all the time. Medical malpractices like that. Somebody has surgery done and the result doesn't come out well. Is it because of the negligence of the doctor, or is it just simply because that's the result that might happen even if the doctor did things reasonably and appropriately under the circumstances? Or even if they did a negligent act, would the condition still have occurred but for the negligence? So it's not always an easy analysis. Business torts, the big one's negligence, and we just went over that. And those are the four elements. I do want to talk briefly about strict liability. If a defendant is engaged in inherently dangerous behaviors, they blast rock to put in pools, or they blast rocks to put in a foundation in a home, that's an inherently dangerous activity. So even if they did everything that was reasonable and necessary as a blasting company, and some rocks still managed to jettison from the area and break a neighbor's window or hit their car, they would be strictly liable, meaning you don't have to prove they were negligent. They did everything right. But because they're engaged in inherently dangerous behavior, we're going to hold them accountable no matter what. Same with drugs. Drug administration or drug manufacturers go through all kinds of trial procedures and FDA approval process. They've done everything that a reasonable manufacturer of a drug would do, but could it potentially harm somebody? Yeah, but we hold them strictly liable because medications that humans consume that prove to be inherently dangerous should have culpability or liability as a result of that. Strict liability is we hold them accountable just because they're involved in an inherently dangerous behavior, or they've made an inherently dangerous outcome as a result of their manufacture of a product. It's very, very dangerous if you're going to manufacture things on a mass scale, because if the item you made is inherently dangerous, you're now liable to almost everybody that either has property damage or physical injury as a result because of that negligent or dangerous design. I don't want to say negligent because you don't have to prove negligence with strict liability. There is a test question, by the way, on strict liability. It's a very powerful tort claim by plaintiffs against a defendant, and it can bankrupt the defendant. That's one of the side issues I want to bring practically for class. Some people want to know some practical skills in business law. Always try to buy liability insurance if possible and affordable, because it helps you sleep at night, one, and two, it gives you that knowledge knowing that it won't perhaps bankrupt your business if you do have liability insurance. And then later in the book or in the course, we're going to talk about business organizations, and those kinds of organizations. They may also shield you at least from personal liability financially for tortious behavior. And we'll go over that in a later chapter. And the book talks about interference with a contract or economic advantage. Some of you that are like really into sports, there might be somebody who's a baseball player for one team and they have a contract with them and they're not supposed to talk to other teams until free agency opens up. And if that other team entices them during the period of time they're supposed to be playing with Team A, and Team B entices them to break that contract and go play with the other team, that is actually a violation of contract law. It's a violation. It's an interference with either contract or interference with economic expectation. And the book does a pretty nice job on considering that. I do have to touch a little bit about copyright and trademark infringement. Think about it. If I write a novel or I create a play or a musical creation, I should be able to own that, and people shouldn't be able to economically or otherwise use my creation for their benefit or their enjoyment without my consent. And that's called licensing, when you give a consent. Trademark is probably more important than copyright, but copyright's significant. It's actually in our United States Constitution. Trademark, you do some branding. I don't have a Rolex watch, but if I had a Rolex watch, we know Rolex is identified with fine craftsmanship and expense and worth and all of that. Imagine if I came out as a watch manufacturer and said, "Hey, let's call our watches Rolex as well. Let's jump on that bandwagon." You can see how that's fundamentally unfair. And it's not always a clear delineation like that, because somebody might not call their watch Rolex. They'll call it, Bolex, or they'll use a symbol that's related to like a Mercedes or a BMW. Some of these products that have very strong branding and market appeal, they'll try to come close to mimicking them without using the identical and saying, we're not doing any trademark or service mark infringement. Trademark's for a product or an item. Service mark is for a service that's done in the industry. But the book does a nice job outlining the test for how we determine whether there's been trademark or service mark infringement. And there's basically 8 elements: the similarity of the two marks, the similarity of the products or services being supplied. It's the same analysis whether it's a service industry or a product. The similarity amount of advertising, the kind of customers that they're looking for, the area of overlap of use, the intent of the parties to use that, adopting the marks, the strengths of the marks, and the actual confusion by the public. Because if the public's not confused at all, there's really no harm to the defendant, and therefore there's no trademark infringement. It's a good idea to register your trademark. You don't have to, though, but it's always good, because how do you prove that you had it first? By registering it, you get a little bit of at least proof that you, in fact, hoped to protect that image. My father was a plumber, and when he wanted to get my brother and I in the industry early before we got licensed, he wanted us to do drain cleaning, because you didn't have to, I guess, be a plumber to do drain cleaning. We had all these augers and power snakes and things like that. And he actually wanted to buy vans and put the same exact symbol that the Roto-Rooter service, I don't know if that's still around, but when I was a kid, it was fairly famous, and they had like a guy that had basically a sewer clean out tool that made it look like a tornado going down a sewer line to clean it out. And I remember even as a kid knowing there was something kind of wrong with that. Isn't that the mark of that other company? You see how that can be possibly wrong? And you also don't want to dilute your trademark. You don't want somebody else to use it, even if you can use it for a completely different product. I'm a Cadillac manufacturer, I'm GM, and all of a sudden somebody's making Cadillac toilets because they want to make it sound like their toilets are the finest and most comfortable ride. I don't know. And you can see how that, although it doesn't have any confusion with the public, doesn't it dilute the ability of Cadillac to be earmarked just to their product? And so they can take some civil action and shut down those things through an injunction or something like that. I always find that area of law kind of interesting. Those of you that are older or just simply like older movies, there was a movie with Eddie Murphy called Coming to America, and he worked at McDougal's right across the street from McDonald's, and it had golden arches and everything else, and they sold exactly the same menu, I think, as McDonald's, and the owner was constantly getting these cease and desist orders. But his name was, I believe, McDougal, and he was trying to argue, well, because my name is McDougal, I can't possibly be trying to rip off the industry icon of McDonald's. But I think he got shut down in that movie. But I thought the movie did a nice little job on that topic. Business crimes, I'm not going to really spend any time on. That's pretty much straightforward. I'm not going to even spend time on the RICO law, other than knowing that sometimes organized crime gets involved in influencing legitimate businesses. And if you can prove that 2 or more entities conspired with illegitimate money or proceeds to invest in a legitimate business, that would be unfair to me if I did everything legitimate from day one and they're competing in the same industry as me. RICO can be brought, and all you have to prove on a civil level, prove by a preponderance of the evidence that the parties had conspired criminally. And I think it's the past 10 years. I don't always remember all the elements because I don't do this very often in my practice, but it can shut down that business and it can stop competitors who started from an illegitimate source of revenue or assets to be a competitor in an industry that started up with legitimate, hard work and legitimate assets. But RICO has been a bit abused, in my opinion, because at one time RICO was really just to go after organized crime. Now it's used in many different realms where two or more entities entered into a basically joint enterprise or a conspiracy to get involved in a business. And I just think the government uses it a little bit more potently than they meant to in the business world when it was really meant to be a criminal statute. But it is what it is, and I hate that term, but it has gotten broader and it's been used a lot to shut down businesses that have an illegitimate sort of source of funding or a startup. And I will talk a little bit about copyright, just if this makes you interesting, you turn it off now if you're not too interested in it. But I can tell you a story. When I was first practicing law, I used to do real estate transactions, and the forms were really a nuisance to fill out and do. And I used to have to do them on a typewriter with ribbon paper, carbon copy paper, so you get multiple copies. You make one error, you'd have to start from scratch. And I can remember I was at court one day, so I can get back to the office. I got this real estate transaction, and the numbers keep changing because we changed the closing date. And I'm his attorney and all the guys. Said, why don't you have easy soft closing software? And this is when computers were first coming out. We had these big 3x5 or 5-inch floppy disks. Go stop by my office and pick it up. You can load it on your system. It'd be great. And I did. It was fantastic. Didn't pay a penny. My buddy gave it to me. And then I got a call from a solicitor and goes, hey, we see you do real estate transactions in Worcester County. Did you ever think about buying easy soft closing software? It's a great product, and it's X number of dollars, and you get all these supportive documents, and it makes it easy to change them over time, and it just prints off from this, I don't know if it's called a PDF or whatever. It takes information. We just plug in numbers and names and things. And I said, well, I already have it. And then right in that moment, when they said, well, how do you already have it? We have a list of people we've sold it to. We never sold it to. And then I panicked. I said, I got to go. I have to throw up or whatever. And I hung up. And I realized, what did I do? I violated someone's copyright. And many of us download music and we don't pay for it. And there's a real question, do we have the right to do those things? And a lot of people think, hey, it's out there. It's on the internet. We should have a right to use those things. It's not always the case. People have a right to own what they've created. And they have a right to sell it to whom they choose. And they have a right to limit the further sale of those goods or concepts or intellectual property beyond that. But I always found it funny because I think I'm a good person, I'm ethical, but I didn't think I was doing anything wrong until that moment that it struck me. No, I didn't send any money into EasySoft, but I did buy my own software package about 6 months later from a competing company. Not because I felt guilty, but it was better. But I think many of us have thought, hey, that went too long. I'm 18 minutes. I apologize. You guys don't even have to look at the video. Just listen to it background. It might help you with some of the concepts. But there are a few questions about negligence, I think, on the test. Certainly strict liability and copyright infringement, I think, is on there a little bit. Not in big detail in the first test because I think it goes through chapter 1 through 4. But there's a few issues on there. It's open book, open notes. It shouldn't be too difficult, I hope. Chapter 4 is going to be much easier. I'll get it on there. If not tomorrow, certainly Thursday. See you soon. Let me know what you think of these videos. Hey, they're way too long, man. Cut to the chase. Don't tell so many side stories. Or I like the detail. I like what I hear. This is good for me. And if you have any suggestions about what you'd like to see in the video or want it different in some way, don't be afraid to let me know. I take criticism like everybody else. It initially wounds me, but what does it do in the long run? It makes for an improved product down the road, and we certainly all want that. And otherwise, be well, and I'll have chapter 4 up in the next day or two. Thanks.